Welcome everyone, we're just getting started. We will be starting everything in the next 5 minutes or so.
hear me? Can anybody hear me? All right. Welcome, everybody. My name is Damin Murdock. I am a lawyer from Murdock Chang Legal Practice. We have a law firm in Sydney and in Melbourne, and we have been working with LawPath for many, many years. LawPath is the largest legal technology in the country. They have about 1,000 lawyers on their platform, and they have a lot of various legal documents that are available to their subscribers. The purpose of this presentation is not to sell anything, to plug anybody. The purpose of this presentation is to help everybody and as many people as we can right now to get through the times that we're currently having. So what we intend to do is to walk you through some of the applicable law and guide you on a path so that you can help your business succeed or at least maintain its status quo during this period. So what we will be doing is we're going to start off with occupational health and safety. Last week, I did a webinar, which is available online, which is very comprehensive employment law. I will be rehashing what I said during that webinar, but not for the first 30 minutes. The first 30 minutes are going to be discussing about occupational health and safety, making sure you have your measures in place, and then having a look at the work or the JobKeep and the Jobseeker payments, then moving along to weighing up OH&S requirements with the Jobseeker, JobKeeper payments, annual leave, long service leave, untaken leave, redundancies, and get into some of the other government grants that are available. Feel free to ask as many questions as you like. I will be answering as many as I can, most likely all of them. I don't have any limitation today in terms of time, so I will try to get to all your questions at the end. If you have to go for whatever reason, then it's more likely than not that I will have answered your question at the last 20 minutes of this webinar. So feel free to stream online and skip ahead to see if your question was answered at the end of this. Now let me just make sure that everybody can hear me okay. And let me also make sure that you can see my screen. It'd be great for you to tell me what state you are in, what industry you're in, and I can try to tailor some of my presentation towards that as well as we're moving forward. To begin with, we're going to start with occupational health and safety. It can be a topic that people may be overly interested in the past, but it's definitely very important now. And the reason is as an employer, you have different obligations based on your industry, and those different requirements are, well, they vary, whatever industry you're in. If you're in hospitality, you clearly have different requirements than those in law. We're going to start off by just talking high-level occupational health and safety in terms of where you can get sources to stay up to date. I will get into what you need to do as an employer and what your obligations are, but I won't hash on about it for that long because I know a lot of this you can find yourself. So we'll just do a high level so you have a good understanding of what the requirements are. I've inserted a link here to the World Health Organization. That's essentially where a lot of the data is coming from. The World Health Organization posts information. From there, the governments then rehash that information and create guidelines. So to stay on top of everything, you can go to the WHO's website, and there's a document there talks about getting work ready. You've all heard this on the news. You all know what the requirements are. Disinfect surfaces, hand sanitizer, display signs, access to face masks, ensure your employees who have mild symptoms stay at home, and all your meetings should be held electronically if they're not required to be done in person, and follow the local laws. Now, people will have many questions such as, we are a company, do we have to provide masks to all our staff if they're working in the office? Do we have to have access to hand sanitizer if we cannot find it? Do we have to increase the amount of cleaning that we do in our office if we have staff working in our offices? The answer to all of those questions are yes. If you are going to have your staff work from a physical office, then you need to make sure that you and your staff are complying with all of the governing rules and directions from the government. So you should have hand sanitizer available to your staff, but you don't necessarily need masks, because if you're 1.5 meters away from each other, then you most likely don't need a mask. I'm not going to get into the medical reasons for that, but obviously you would have read up on this and you probably know most of it, or just as much as I do. Other government websites, you have the federal government, again, saying wash your hands, cover your mouth, avoid contact with others. And then you have WorkSafe, and that's primarily where we're getting into. Now, this presentation is not necessarily New South Wales focused. It is just an example, but most states have very similar OH&S laws. And there is a federal model law that the federal government has come out with regarding occupational health and safety, and that model law has then been enacted by almost every state, which result in a unified OH&S law, except for Western Australia and Victoria. However, if you are in Western Australia or Victoria, not to worry, because there are clauses and sections that are almost identical or very similar to what I'll be showing you in a moment. Now, Safe Work New South Wales website, I've given you a link there. And then you also have the similar ones in all the different states. They have special alerts for different industries. And to give you an example, many, many years ago, I had a client and someone died at work. And when that person died at work, by the Monday following that incident, WorkSafe New South Wales had issued a new alert about A-frames holding glass, because in that case, that's what it dealt with. So WorkSafe is on the ball in issuing new alerts, giving guidance, giving procedures, and you should look at your specific industry to make sure you're following the requirements necessary based on your industry, if there are any information on your industry. There's a fair amount of accountants, and there most likely is not any policy or alerts dealing with accounting firms. But let's go into the primary duty of care. The primary duty of care is that a person conducting a business or undertaking a business must ensure, as far as reasonably practicable, the health and safety of their workers, or any work that they are causing those workers to perform, or any activities they're doing for the work, is compliant with the health and safety legislation. And what that means is that you need to make sure that the environment that those people are in is safe. And to ensure that the environment that they're in is safe, your obligation is have hand sanitizer, make sure you clean your office, make sure everybody stays 1.5 meters apart from each other, make sure you follow the rules in terms of per square meter and how many people you're allowed to be in a room at that time. And if you follow those procedures, you've now provided a safe working environment to the company or to the government standards of what's expected from you. But if you're in construction, there might be different procedures, and those procedures are going to be listed on the Safe Work website or on the federal government website or on the Department of Health website. And there's different publications and fact sheets being published every day by the government dealing with this. And one thing that we've realized as a lawyer is that most people thought the government might not be that productive, but in the last couple of days, they have been extremely productive. It is incredible how fast they're able to draft legislation, and reading the legislation, they've been doing a good job on it. And the documents that they're producing, the fact sheets, the content that they are producing is significant. They have procedures for construction, manufacturing, accommodation, hotels, airplanes, if they're still flying, items like that, or businesses like that. There's different fact sheets. You also have an obligation to monitor your staff. And a lot of people are now working from home. And because they're working from home, you might not be able to go into their home and to review their setup, but there are certain things that you can do to make sure that their health and safety is being taken care of to a reasonable satisfaction and as far as reasonably practicable. And that is zooming them in or getting a video or FaceTiming them, having a look at their setup. Do they have a comfortable chair? Do they have a desk? Do they have their home office set up? And if they do not, then you must consider whether you're going to buy a chair for them or allow them to come and collect a chair and maybe pay for their Uber or their taxi to get that chair home. Do they have 2 screens? That's not a health and safety issue, but that's a productivity issue. And as a lawyer, we've been reducing the amount of paperwork that we actually print, and we use 2-3 screens. But you must consider, should your staff actually have access to an extra screen, because they'll be much more productive that way. That's not a health and safety issue. That's just something about working at home. And with people being locked down, there are concerns for mental illness and cabin fever, what we call in Canada. And what you should consider is staying in touch with your staff, making sure you're in regular contact with them, and asking them those questions. How are you doing? How's your productivity? How's your mental health at the moment? Are you getting enough food? Do you have access to everything you need? Are you getting outside? Are you exercising? And so on. Those are the kind of questions as an employer you have an obligation to do, because that's your duty of care, and that's a primary duty of care. There are then individuals in the company that specifically have a duty of care. And you may have heard that these individuals can be found personally liable if the duty of care is broken. And in most states, there's criminal sanctions against that individual if they have grossly or negligently or recklessly not complied with their duty of care obligations. And those duties are set out as staying up to date with the OH&S regulations. Have a look at your websites, your government pages, make sure you're always up to date on that. Have a look at it. It's always adapting, it's always changing, but probably staying up to date at least once a week is reasonable. Understand what kind of risks you might have in your workplace. As a solicitor accountant, I joke about it. I said, well, what kind of health and what kind of risks do we have? Are we going to get a paper cut, or what's going to happen to my staff? The reality is that you got to have the workstation properly set up. You can have back injuries, you have carpal tunnel disease, but most of it's mental health, and mental health is also very important right now. And there's a specific obligation for you to make sure you're staying up to date and sharing that information. And this presentation will be available to everybody afterwards. So if you do want to knock off and leave this presentation, you will have ability to download it and stream it online afterwards. Workers, employees, they have an obligation as well. And I'm only going to harp on about OH&S for another 2 minutes because most people here want to hear more about the employment, the job seeker, and the job keeper. But this is really important to deciding whether you keep someone in the job, whether you change your roles and responsibilities, or whether you make someone redundant, or whether you stand them down. And that's why I'm focusing on this, because it actually is very important in how you actually deal with your staff moving forward. But as a worker, they also have obligations to make sure that they take reasonable care. And if they're not prepared to follow your instructions, then the reality is that they're breaching, most likely, their employment contract in the sense that they're not following reasonable direction. Or alternatively, they are committing serious misconduct in the sense that you've given a lawful direction or you've had a policy and procedure implemented and they're not following it. So I will get to the question that a lot of people have is, my employee refuses to come to work because they're concerned. What do I do about this person? And this issue becomes relevant because the question is that if you've complied with your OH&S requirements, the officer of the company has complied and have provided a safe working environment, and the employee agrees to comply with all their OH&S requirements, then why can you not require them to perform their duties at work? And what is the reason why they're not agreeing to come to work? And what can you do with that employee as a result of them refusing to come to work? There's a lot of people out there who need jobs, and if some people aren't prepared to do their job without a legitimate expectation or reason, then there is a possibility to hire someone new. And I'll get into that in a moment. Now let's look at the JobKeeper payment. The purpose of the JobKeeper payment is not to pay you 100% of what your staff are making so that you don't have to pay wages for anybody. The purpose is to give you a subsidy to reduce that overhead. And together with that subsidy and all the other subsidies, it's actually making it viable for businesses to continue to trade or stand people down and have them back up the minute this all ends and working for you, rather than having to go and recruit new staff and dragging that out for an extra month or two, going through the whole recruitment phases all over again. So who is an eligible employer for the JobKeeper payment? And yes, you can share these slides with all your colleagues or whoever you would like. And it's in the public domain because it's now on YouTube, LinkedIn, and Facebook. Now, so when you're looking at the JobKeeper payment, there's about 4 steps. Step 1 is, who is an eligible employer? I have not gotten into employers that have over $1 billion turnover, because that's not necessarily our target audience right now, obviously. Our target audience are those with less than $1 billion, obviously. So the question is if your turnover has fallen by more than 30% or 30% or more as a result of COVID-19, when comparing to a typical month in the last 12 months, then you're most likely going to be entitled to JobKeeper payment. There were some misstatements made by the government originally, which have now been clarified. So if you looked at what the JobKeeper payment eligibility is on the day it was issued, that's going to be incorrect. And a lot of accountants have released a lot of information. That information is not 100% accurate as of today. A lot of people believe that you have to look at your March 2020 turnover and compare that to your March 2019 turnover. And when doing an exact comparison, if there's a 30% less turnover, then only those employers are entitled to the JobKeeper payment. That's incorrect. In fact, the government is trying to expand it so it applies to as many people as possible. And I'll get into step 2, which is which employees are entitled, but right now, step 1 is which employers. So the ATO has issued new information, as well as the government and other sources, that say, we look at your usual or average turnover, and has there been a decrease? That's very broad. That's very, very wide. And they also look at, has there been a significant effect on your business as a result of that? Ultimately, what they're doing is they're saying, we want you to act in good faith. We want you to look at these rules and act in good faith and do the right thing. And the question is if you're not sure, then you can most likely contact the ATO. But right now, what they want you to do is register, apply, and they're going to be flexible, and they don't want an influx of calls and having to assess everybody. So they're going to use their discretion and have a consideration to your specific circumstances later. But you look at your business and just say, has there been an economic turn down, and has that resulted in my turnover being reduced? The tax commissioner has a discretion looking under the next 12 months as looking at whether you even have volatile revenue. So even if you know it's going to be up and down, there's a lot of them saying, maybe it's not even down now, but I know it's going to be in a couple weeks. You will likely still qualify. This is a very wide interpretation. Parliament's going to be sitting next Wednesday. Today's the 2nd of April. Next Wednesday, we'll know the specifics. But we've already got enough guidance to understand, and we recommend you register and apply, and you can always withdraw your application. Step 2 is looking at who is an eligible employee. An eligible employee is anyone who was on your books on the 1st of March. Even if you've already stood them down, even if you've terminated them, even if you've made them redundant, you can re-engage them, and they'll be eligible for the JobKeeper payment as long as they were on your books on the 1st of March. This applies to full-time employees, part-time employees, and casual employees, but only if they've been on your books for 12 months as at the 1st of March 2020. It does not apply to anyone under the age of 16 because they have other benefits. It does not apply to anyone within the pension range because they have other benefits as well, if they're receiving those benefits. It does not apply, which a lot of people are asking, to 457 visas, 482 visas, sponsorship visas, bridging visas, temporary holders, but it does apply to New Zealanders holding a 444 visa. And if you're on any special category of visa, you're most likely entitled to this, or if you're on some kind of visa that's been able to keep you here for 10 years, then you're also going to be entitled, that employee is going to be entitled to it. It also includes self-employed companies or individuals who have an ABN. There's an extra level that's required for those self-employed, which is providing a statutory declaration at the beginning, discussing their turnover and why that is being reduced. And yes, it is only casual employees who have been on the books for 12 months. Now, obviously, this is changing regularly. The government's already produced, I think, 3 different fact sheets since the day it was announced, updating and changing what they originally said. So it could change, but I'm not sure at the moment. Step 3 is the employer then applies. And yes, it does apply. I'm answering some of the questions as I go, so you might get that. Yes, it does apply to some sole traders who work for themselves. It definitely does apply to those situations. The government does not want lineups outside the Centrelink offices. That's what they're trying to do. They're trying to get employers, including ABNs, to take care of themselves. They're trying to get them to relieve the Centrelink offices and to reduce that burden on them and put it in the hands of the companies to go through the process and do it. So that's just to give you an idea of why, another reason why this is being implemented. And you would have seen on the news all the lineups outside of Centrelink and the people that haven't even been able to get in there and the people who aren't necessarily social distancing while they're in line at Centrelink. So to sign up as an employer, apply. Apply now. There's no reason why not to. You can withdraw your application. Fill in the application. You must identify which employees will be receiving it. You might run a company, and in that company, you may have decided that half of your staff are being stood down and the other half of your staff are still continuing, as is. If you're going to make that election, you got to be very careful because you got to make sure you're not being discriminatory. You have to make sure you're acting reasonably. You have to make sure that you're doing this for a reason. And I always recommend to my clients to make sure that they are doing a matrices, a spreadsheet. What are the positions? What are the jobs? What are the duties? What are their salaries? Can they still perform their duties? If they can, how many hours? Are those hours reduced? Are those hours the same? Are those duties no longer required or not possible? And so on. And go through that, and that's how you should identify who's going on it and who's not. Because you have to do it fairly and reasonably. And that's all under the Fair Work Act, dealing with employment law. And so once you sign your employee up to this, you will then be paying your employee their normal wage, if you haven't, and I'll deal with this as well separately. You'll be paying them their normal wage unless you've changed it. And if their normal wage is more than $1,500, you'll be paying them that wage. And then the government will be reimbursing you on the 1st of May or soon thereafter, $1,500 back. And the superannuation on the JobKeeper payment above the, so I'll just be very clear on this. If Joe makes $1,000 a fortnight, you are required to pay Joe $1,500, and then you'll get back $1,500, and you don't have to pay superannuation on the extra $500 that you topped up. But you still have to pay your super on the $1,000. And I have an example in the next slide. So how does it work? Again, as I mentioned, it's about not over flooding the system that we currently have with Centrelink. The amount of jobs that are being made redundant or stood down is resulting in a lot of pressure. It's to take that pressure off. It's to minimize terminations. It's to minimize redundancies. It's to keep people in a job, or at least keep them getting some kind of money in so that they can pay their expenses. There's another program that's available to you as well. And that program is the Cash Flow Assistance Program, which I talk about later on in this presentation. But that essentially says that all of your tax withholding on your salaries from the 1st of March to the first, or for the next 6 months, all the tax withholdings that you're withholding, you'll get a full credit back up to a maximum of 50 grand. And I'll go through the step-by-step process for that as well. So let's just have a very quick look at employee number 1. Normally receive a pay of $3,000 a fortnight. You pay the $3,000, you pay the super on it, you withhold the tax on it. The ATO will then refund you the $1,500 via the JobKeeper payment. Employee 2, as I mentioned, which was Joe in the last slide. Joe makes $1,000. you normally pay Joe $1,000 and you pay super on this $1,000. You then pay him $500 more. There's no super required on that, and the ATO will pay you back the $1,500. Someone's asked, what happens if someone makes $3,000 a fortnight but is stood down without pay? I'll get to that when I get into the specific employment law issues, because there are some strategies that an employer can implement to reduce their burden and reduce their overheads at the moment. Everybody was talking about the Jobseeker payment 2 weeks ago, and then the JobKeeper payment came out. No one's talking about that anymore. So you need to know what the Jobseeker payment is, because if you do decide to make your staff redundant, and they are entitled to JobKeeper, but you still aren't terminating them for any other reason other than you can't afford them, you most likely want to look after them, and you need to know what the rules are for that and make sure that they're looked after. And so the Jobseeker payment is someone that's being dismissed or stood down, and I'll do a comparison between the JobKeeper and Jobseeker in a second, over the age of 22, under the age of the pension age. It applies to self-employed casual workers, contract workers who now, as a result of them being stood down or taking unpaid leave, their income is less than $1,086.50, then they're going to be entitled to the Jobseeker payment. If an employer closes its office, so these are some of the questions my staff or my clients have asked me in the last couple of weeks. If you close your office, is the employee still entitled to the Jobseeker payment? And the answer is yes, as long as you can have a look at that. Yes, as long as they overcome the income maintenance payment period. So if you make someone redundant, you pay them out their redundancy pay, say that's 4 weeks, they now have an income for the next 4 weeks. And normally the Jobseeker payment won't kick in until after that redundancy pay has been used up. There has been discussion about waiving that maintenance period. I'm not on top of exactly every circumstance at the moment regarding the waiver of the maintenance period and how it applies to annual leave, long service leave, and redundancy pay. If an employee offers an employer to take a reduced salary, is the employee entitled to the Jobseeker payment? Yes. If it's a casual and as a result of the reduced salary, they go into the income, or they fall below the income threshold. And yes, if it's an employee who has now been stood down or dismissed. If the employee is made redundant, but is redeployed in a new role, which now results in them receiving 20% less pay, are they entitled to the Jobseeker payment? Yes. But now I probably confused you, because now you got the JobKeeper and you have the Jobseeker payment. And which one is going to be best for your employee? And which one's going to be best for your company? It's very hard for me to tell you open slather which one's the best, because everything is going to be based on your circumstance. But the government is certainly promoting the JobKeeper payment. From a company's perspective, you want them still on the book running next day, and maybe your employee doesn't go and find another job. The purpose of this is to start your company up right away, right when this all ends. And so if you want to be able to be first to the starting line, then you're going to want the JobKeeper payment, because that employee is now locked in there with you, is still employed. But there are certain circumstances where you can't pay your employee the normal wage, because they might be on $3,000 a fortnight, and you might only be receiving $1,500 from the JobKeeper, and that's still $1,500 out of your pocket. And if they're not doing anything and they're not working in the business, then how are you supposed to maintain your cash flow? You can't. And so that's where we're going to go to now when we start talking about employment law. And that is, what is going to be better? Do we stand them down? Do we make them take annual leave? Do we make them take unpaid leave? Do we make them redundant? Do we put them on the Jobseeker? Do we put them on the JobKeeper? So let's get into employment law, high level. And this is where my slide from last week started. So if you were in my previous webinar last week, a lot of this will now be a rehash. So you might want to leave if you want and come back again and stream the questions. Or I will be covering different questions, talking about what if my employee doesn't want to come back to work, and that's new content as well. So the first thing is, you are going to have some employees who may be on a modern award. If you're in hospitality award. If it's an administrator, it might be a clerical award. If it's construction, it might be a construction award. If it's manufacturing, it might be manufacturing. It doesn't really matter, because what awards do is they standardize the minimum requirements, the national standard for those set of employees. But almost all of the awards are same in certain aspects. And a lot of them have the same kind of clauses in all the awards. And the first one is, you'll find in most awards, Clause 8. Clause 8 is talking about consultation. And it says, if an employer makes a definite decision to make a major change in the production, program, organization, structure, or technology of the business, which is likely going to have a significant effect on an employee and the employer must give notice of that change, discuss the effects with that employee, implement those changes, tell the employee how those changes are going to affect them, and take measures to avoid or reduce the adverse effects that it's going to have on your employee. And have those discussions as soon as possible and to take reasonable steps. Now you might say, but my staff are not on award. It doesn't matter. This is good practice. This is what Fair Work Commission will be looking at when you decide to make someone redundant or to stand them down. You have to act reasonably. And reasonably is communicating with your staff and keeping them up to date and making sure that they know what's going on as well. That's fair and reasonable. Making a decision is not necessarily fair and reasonable without discussing it with them and telling them what you're going to do about it. The second clause that you'll find in most awards is clause 34, sometimes 24, but it's called annual leave. It's under the section of annual leave. And under the section of annual leave, it has normally a section that says close down. And it states an employer may be required or may require an employee to take annual leave by giving at least 4 weeks notice as part of the stand down process. That's under the award. Now, that again has a notice period, but not everybody's on an award. And there are circumstances where you may be able to have that notice period potentially varied if it's by way of mutual agreement with your staff. But these are statutory laws and you can't get around them. So if you are on award, you got to follow the law, but there are different measures that you can take that may be available to you to get around that explicit section. You may need to get legal advice on that. But let's look at that, closing down. If you force an employee to take annual leave, the question is do you have a clause in your contract that allows for that? Possibly not. Are they under award? Possibly not. So what do? When can you just simply tell them, look, the work's gone, we're going to force you to take annual leave. As a law firm, as a construction company, we have industry shutdown periods. A law firm, they close normally from the last Friday before Christmas, and they reopen on the second Monday of the new year. That is a forced shutdown, and unfortunately, my staff are required to take annual leave at that time. And the same thing goes for construction industry, because for us, the courts are closed. But if you're not under an award and you don't have anything in your contract, you need some more guidance, you look to Section 94(5) of the Fair Work Act. And that doesn't have a notice period requirement. That just says if it's reasonable. So what's reasonable? You look at whether your company has had a major downturn. You do a matrices and you look at all your different staff and say, this job I still need, but on reduced hours. This job I don't need anymore. This job I need, but I actually need it more because now we're doing digital marketing for a bunch of people. So maybe I'll redeploy this staff into that area. So you've got to try to understand your organization and be very reasonable in how you do stand down. Doing a full stand down across the board might not be reasonable. There may be still jobs that still need to be performed. So you've got to look at that and act reasonably. Some of the questions is, can I dismiss an employee because they have COVID-19? Well, I think most people would know that the answer to that's no. It's kind of absurdity, but a lot of people ask that question. And the reality is if you were to terminate someone because they were sick, that's an unlawful termination. It's also a general protection. They've exercised their workplace right to be sick, and as a result of being sick, you've been terminated. That's Section 340 and 341 of the Fair Work Act. You have dismissed someone because they're absent from work. That's unlawful. That's Section 352 of the Act. Under the regulations, they need to be sick for more than 3 months and not on workers' compensation. Can you enforce staff from coming into work if they are sick? Yes. Your OH&S, and this is where all the OH&S stuff I started at, is now going to start being discussed. You have an obligation to keep people safe. That's in your workplace, all other people, including yourself. If someone's sick, they must not come into work. They can take sick leave. If they don't have any accrued sick leave, you can force them to take annual leave. If they don't have any annual leave, you can force them to take unpaid leave. They must not come into your office and make everybody else sick. They have a duty under the OH&S laws as an employee to comply, to follow your direction. So yes, you can force self-isolation. They have a duty, you have a duty, and you all have a duty to each other to keep everybody safe. Now let's talk about working from home, and then I'll get into staff who refuse to come to work because they're afraid that they could get COVID or they could infect somebody else or one of their loved ones. LawPath has a great working from home policy. It's free. It's on their website. You can Google it. You can download it. You can implement it. A lot of people say, oh, I've read it. It's really strict and it's really compliant and that's not the vibe of my company. Well, the reality is that you have all these legal obligations that I've just gone through. You must comply. You must follow the rules. In Section 19, duty of care. Section 27, being on top of all the applicable law. Being adaptive, knowing the new information. Working from home policy is the bare minimum. It's the minimum requirement that's expected. We are going to stay in touch. We're all going to download Zoom. We're all going to keep our time recorded. We're all going to observe our performances. We're all going to have a desk and a workstation which is compliant. We're all going to Follow the rules that I've just gone through. I also have discussions with some of my clients who are saying, well, you know, am I liable for my staff working from home? And if their house burns down, is that my fault? Well, that's going to be getting into some difficult insurance disputes, isn't it? If you looked at your client's work setup and you saw that there was 15 different cords plugged into the same power bar, and they had a power bar plugged into another power bar and plugged into another power bar, well, that might not be a safe working environment, and you might recognize that. And if the house burns down as a result of that, well, is it going to be your employees' public liability insurance or house and content insurance that's going to kick in? Or is it going to be your public liability insurance that you have as an employer and the work cover that's going to kick in? That's a battle for two insurance companies. But what I do recommend to you to say is you should probably tell your staff, if they're renting, to double check and make sure that their rental premise has certain minimum requirements that are required by law. Do they have smoke alarms? It's required by law. If they don't, go get the landlord to get them one right away. Monitor the communication. Make sure people are being productive. If you do not have some kind of method to track your staff, then you better implement it right away, because you're not going to know whether you're being productive. And that means you're not able to predict what might happen in the next month. You need to know exactly what people are doing. People might say, oh, that's micromanaging. That's not my style. It's not about micromanaging. It's about making sure people are productive and doing something, and you're able to track them and make sure they're doing something. Because if they're not being productive, you're not going to have, you have an overhead that's not being utilized. You're going to have cash flow difficulties. There's a free add-on tool to Xero. It's called Workflow Max. I think it's free up to 10 users. It's a very simple platform that just tracks files and time. It's basic. You can just do an Excel spreadsheet. You can have a Google Doc, something like that. Or there's various other systems available. You can use Slack. It's also free. That's a communication tool between staff. You have Zoom, free again, up to limitations, obviously, to communicate and video your staff. Now let's talk about redundancies. You now have to decide if your staff are not being productive and are not covering their own wage, whether the job payment coming in will then be able to subsidize their wage so that you're now not having those cash flow difficulties, or whether their wage less the job payment is not good enough and it's killing your business. I am not advocating making anybody redundant. My job here is to make sure everybody understands what their obligations are and to make sure they do the right thing by everybody. But you, as a company owner, you got to look after yourself as well, and you have to make difficult decisions. And if you have an employee on $3,000 a fortnight and you're only receiving $1,500 a fortnight back, you're out of pocket $1,500 a fortnight. Does that now mean that that person's not doing anything and not covering that $1,500 and your business is going to collapse as a result? Do you need to make a redundancy? Or do you need to stand them down? And if you stand them down, and as a result of standing them down, they end up going on to the Jobseeker, then that might be better for your company. So for instance, if you stand them down to zero salary, you don't put them on the Jobkeeper because they were at $3,000, you're only going to get $1,500 back. You're going to be out of pocket $1,500. That means you got to, and they're not doing anything, you might need to stand them down. If you stand them down to nothing, then they're going to be entitled to Jobseeker, most likely, because in that circumstance, their salaries dropped by 20%. But can you just go and dump them and say, I'm not paying you anything, because that's what we call constructive dismissal. You're changing the terms of the employment unilaterally without the employee having a choice, and you're making their job now so intolerable because you're not paying them, and you're breaching the national employment standards on not paying them the minimum salary, which is required by law. So if you stand them down to nothing, you're possibly unfairly dismissing them. You're also possibly have a Fair Work Ombudsman claim against you for not paying them anything, unless there's a mutual agreement. And if there's a mutual agreement in writing between the parties, even then, you've got to consider, well, have I just forced my client to sign that? Was that under duress? Is that going to be binding on me in the next 6 months, or 6 months from now, or a year from now, when the employee comes back after 6 years saying they didn't get their entitlements they're entitled to? It opens up a lot of risk, and you got to be very careful. And there's other opportunities where you can potentially get into redundancies. So a redundancy is where the job is no longer required. I have a staff. That staff works Monday to Friday, 9 to 5. However, I don't need that staff 5 days a week anymore. I don't need that staff 5 days a week anymore because we've had a downturn in our turnover. And as a result of that downturn, we don't have the capacity to be paying that anymore, and we don't have the roles and responsibilities for that person anymore. So we're going to make that position redundant. We're going to make that position redundant because of operational changes. And now, number two, when you make something redundant, you now have an obligation to redeploy them into a new role. And you have to look into your company and say, is there a new role available? And you can say, I don't have the 38 hours per week role for this anymore. I'm sorry, we've had a huge downturn. But we do have a role available which is on a 3-hour or three-day basis, but it's at a reduced salary. Do you want that role? And if they say yes, they've then become redundant. You've now redeployed them in a new job. You don't have to pay redundancy pay or notice pay. You get them to agree that the redundancy happened. Now that their redundancy has happened, if they have any issue with it, they must file a claim with Fair Work Commission within 21 days from the date of the redundancy. If they don't, they're statute barred from bringing a claim against you in the future. If you stand them down, they can claim that you underpaid their wages 6 years from now. You've got to be very careful. The law is very technical. I'm not recommending any method to anybody at the moment. And as you know, this is general advice only, not specific to your business. Obviously, I have to say that. Now, so if that role is being made redundant and you do deploy them into a new role, then you've potentially covered all your aspects. However, you got to make sure, again, that you're taking all reasonable steps and you're doing this for an operational change. And if anyone challenges it with Fair Work Commission, you need to prove that there was a downturn and that duty was no longer required. You can't reduce someone down to 4 days a week or 3 days a week or reduce their salary and then keep them doing exactly the same as they're doing with the exact same roles and responsibilities and still giving them work on Friday when they're only supposed to be working Monday to Thursday. That's not a redundancy. That is a sham. And that will be overturned by Fair Work Commission. Now, what if my employee refuses to come to work? We're getting a lot of inquiries about that. And a lot of inquiries relates to not necessarily your employee having COVID-19, but maybe your COVID is older. Or maybe your employee is living with an older person. Or maybe they are at risk. And maybe they say they're at risk, but they're actually not. And maybe they say that they have legitimate concerns, but there are no legitimate concerns. The Department of Health has issued who are at risk. If you have a staff that says, I'm not coming to work because I'm at risk, or someone around me is at risk, first look to see is that a legitimate concern? Is it a legitimate concern? Are you an accountant with an office that holds 30 people and you're asking for 4 to come into work and you have hand sanitizer and you have masks available and you're cleaning the office and wiping it down regularly and everybody's keeping their distance? What's the risk? What's the risk if no one's close to anybody? Do they need to self-isolate? Well, certainly not by law. You've actually now implemented all your OH&S obligations. You've now made, as far as practicable, everything safe. So what's the problem? Why is that employee not coming? Are they afraid of taking public transport? Not saying anything bad about public transport, but if you take public transport, maybe you're at risk of coming in contact with more people. And if they're commuting and they're standing on the bus or they're taking the train, there are circumstances where they may have more prospects of getting COVID-19 than if they took an Uber or a Didi or one of those, or if they got picked up by somebody. Consider that if your employee says, I'm at risk because I'm not refusing to take public transport, consider the other options. Maybe there are other options to get them to work. Maybe you can rent a company car and say, well, here's a car, here's a parking spot. These are expenses that the company can incur if it means getting your staff to work and putting procedures in place. But going back to looking at why the employee refuses to come to work. If there is no legitimate reason of you acting reasonably, and you've taken all your OH&S responsibilities, and you've implemented your OH&S policies about washing your hands and social distancing and all that, and the employee still refuses to come to work, you can then consider whether disciplinary action is appropriate. Most employment contract says if employees absent from work without reasonable excuse, then that employee potentially is in breach of the contract. You can say pursuant to section blah, 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 we have grounds to summarily dismiss you if you unreasonably follow our policies, procedures, or been absent from work for more than 2 days. That's if you have it in your contract. And if they refuse to come to work, maybe it's issuing a demand, issuing a warning letter. However, you also got to balance, you don't want to force someone to come to work and then they do get COVID-19. That's going to be a problem, isn't it? That's going to be an issue for work cover potentially. And that's going to be an analysis of your internal policies and procedures. And so maybe you've got to look at flexible work arrangements. Maybe it's, we'll only bring you in once a week, but we need you to attend once a week. Maybe it's standing them down and saying, if you can't perform your role, I'm not going to fire you, but I need you here for these reasons, and therefore, we're going to have to stand you down or make you redundant. But if you make someone redundant, or you stand them down, or you take an adverse action against them as a result of them exercising their legitimate workplace right, that's called a general protection. And they can issue legal proceedings against you for taking adverse action as a result of them exercising their workplace right. And that's a very specific issue, and you should get legal advice on that. Now let's change the topic completely. We're now going to get into, and I'm going to go very quickly because I'm already an hour in, and I understand we got a lot of questions to get through. We're now going to get into Australian consumer laws, breach of contracts, termination of contracts, not fulfilling your obligation under contract, suppliers not fulfilling their obligation, you not getting a refund, you trying to give a credit to somebody. Let's get into what your Australian consumer law obligations are. First of all, look at your terms and conditions. Have a look and see what your termination clause is, your extension of time, your variation, your dispute resolution, refunds, credits, replacements, delivery. Those clauses in your terms and conditions or in your supplier's terms and conditions will guide you on what you need to do. But just because certain terms and conditions say something doesn't mean they're legally enforceable. If you exclude the Australian consumer laws, that's an exclusion clause and that's not enforceable. So you need to look at first what the clause says, and then you got to look at what the Australian consumer law says. Most importantly, though, communicate. So what are your guarantees? This is not all of them, but it's high level of what most of them are in relation to goods. They're going to be fit for purpose, free from defects, safe, durable. I had someone that was selling masks, but they couldn't prove that where they came from or whether they actually were N95 masks. Are they free from defects? Are they fit for purpose? That might be an issue. You got to consider it. Are they fit for the purpose disclosed? I act for a very, very large manufacturer, one of the largest manufacturers in the country. And they make very large machinery equipment, and they ran out of a certain vehicle, and they said, oh, you can use this vehicle for this purpose instead. And so they went and used it, and the vehicle broke down, and then my client was saying, well, that's your fault. And they're saying, no, we told you what it was for. We told you why we were using it, even though it wasn't made for that. We told you that what we're going to use it for, and you said okay, and therefore it's fit for the described purpose. And are the goods what they say they are? A lot of people are selling online now. You post a picture saying this is what you're going to get, and you give them something else. You breach Australian consumer law. You can have terms and conditions that say the timber floors might not look exactly the same. This is a sample, but the color might be slightly different. I'm selling flowers, and this is a typical example, but it's not exactly. If you're going to not give exactly what you say you're going to give, you got to have terms and conditions that deal with that. If you're an importer of goods, by law, you're deemed the manufacturer of that good. If you're bringing goods in from overseas and you don't know where they're from or what they are, you have an obligation to make sure, and you should make sure, that that manufacturer has product liability insurance. I had a case where a plumber bought millions of dollars worth of plumbing parts from overseas. He then won a tender for a massive builder. They installed it into hundreds and hundreds of units. Once those units ended up having people in them, they all started breaking and flooding all the apartments. I believe it was around $26 million worth of damage. Did they have product liability insurance? Whose responsibility was it? Was it the manufacturer? Was it the engineer that designed it? Was it you? You should look at getting product liability insurance to cover situations like that. You should make sure your manufacturer has that. You need to make sure you have spare parts in the country. And if you don't have spare parts or replacements or repair facilities, change your terms right now. The spare parts, the repairs, it won't be happening for 6 months because of COVID-19. If you update your terms and make it clear what people are buying and what they're getting, you're going to be safe. But you got to make sure your policies are reasonable as well, because you can't fall foul to Australian consumer laws. Services, due diligence, fit and proper purpose within a reasonable time. I'm a music buff. I have music concert tickets for pretty much everything. I have one of these venues trying to now say, and I bought tickets for a lot of people. I bought about 10 tickets. And I was looking at my bank account to see whether I got the money back, and I didn't. And I looked at the terms and conditions, that say anything, and they're just saying, oh, it's canceled, but it'll be held on another day. We're keeping your money. Thank you very much. Well, you can go to that on another day. Well, that's not what the agreement is. The agreement is not, I will attend that concert next year sometime. There was an offer to attend it on that day. They promised to hold it on that day. They haven't held it on that day. Breach of contract, loss and damage, give me my money back. Unless they have clauses in place dealing with situations like where it's out of their control, force majeure, act of God, pandemic clause, COVID-19. A clause that says we're not going to give you a refund, but we're going to give you credit. You can have these in your terms. Going back to that music concert thing, I'm not obviously exercising my rights as a lawyer. I don't do that. I try to avoid conflict in my personal life, but I'm a litigator in my job. So now let's look at how to minimize the impact of breaching these guarantees. Communicate, communicate, communicate. Make sure you go to your suppliers and send them a letter. Can you just double check whether you're still able to comply with that? You're still able to get me that? You're still able to do this? You're still able to do that? No, we can't. We don't have the resources. We're stuffed. Okay, let me go back to my customer and let me see whether I can renegotiate and come back to you on that. And if your customer then agrees, then maybe your supply chain will agree as well. And you can work it out between yourselves. And this is getting into commercial leases as well. And Scott Morrison said, communicate, talk to your landlord. We don't have something for everybody right now. But what's so important is work through it. Work through the situation. And I talk about commercial leases in a moment. But let's go into financial modeling for the account. There's a fair amount of accountants in this seminar. There's also a fair amount of lawyers in this seminar as well. And there's people from every industry all across the nation. But let's look at financial modeling. So when you go to the financial modeling, you can ask your accountant saying, what's my worst case scenario? What's my best case scenario? When do I need to pull the trigger? Can I afford Joe to continue being paid his $3,000, me getting back the $1,500, me being out of pocket for $1,500, but keep him on some roles and responsibilities for now? And if I do that, when do I run out of money? Have a look at it. Know your future projections, because if your accountant does your worst case scenario and your best case scenario, and you're somewhere in there, fantastic. You can keep your employees on, you can rejig your business and keep on moving through this. But the minute you're about to hit your worst case scenario, you've got to make some difficult decisions. And those decisions might be making people redundant. So talk to your accountant if you have one. I am plugging your accountant. I am saying go to your accountant. They're really important. Manage your cash flow. Look for short-term funding. There are different ways that you can get funding, and I've done a presentation. Again, I'm not plugging anybody, but I've done a presentation with a wholesale investor on different ways to raise capital, and I'm doing another seminar on raising capital and issues with founders with wholesale investor, which is a live seminar next Wednesday, or a recorded seminar, which is next Wednesday. Now, in that one, we talk about raising money. You can get an unsecured loan from mom and dad, friends and family. You can get a secured loan, potentially from the bank. There's also guaranteed funding and guarantees from the government for those loans. If you don't have those, consider R&D funding. Maybe you have to stand down most of your staff. However, your dev team now has an opportunity to build, and develop and do everything that they never had time to do. And if you are now in a situation where your dev team don't have anything to do, this is probably the best time for them to develop, because they can focus on that issue. Look at R&D funding. There's a company out there called FundSquire. FundSquire looks at what you do. They say, okay, I understand it. Let's look at your past projections. Let's look at your cash flow. Let's look at your sales. Yep, I get it. Let's maximize your R&D. We are going to lend you money for you to build up that development. And then you're going to go and get money back from the government for the development that you've done. And you'll pay us back our loan money first. And then whatever's left over, you can keep. Look at facility agreements. Right now, you might have the ability to get a facility. You might have good financial accounting all the way up until now. Apply for a loan. Apply for a facility or a line of credit right now when your finances are good, because they won't be in 3 months, potentially. and you won't be able to get a loan potentially. So look at that. Consider getting a line of credit. You can get a facility. Let's say you get 100,000. You don't need to take the 100,000, but you now have an approval for 100,000. You can then request, give me 10,000. Here's my request for 10,000. They now have an obligation to give you the 10,000. That's a facility. You can borrow up to that amount when you request it. I don't like credit cards, but that's another avenue. Private funding, mom and dad. You can also issue shares in your business. You can sell shares in your business, bring in equity, or sell equity for money. You can also do what's called a SAFE, a simple agreement for future equity. That is, I don't know what the value of my business is right now, and I really don't know how much my shares are worth. But what I do know is that I will sell you shares now, and I will take your money now, and I will do a capital raise later, or at a later date, your shares will automatically convert into a certain amount of shares. We don't know exactly what it's going to be now, but we'll sort it out later. That's a SAFE. You have a lot of abilities to extend your tax debts, your payment plans, and you can get different kind of relief from the government as well. Now I'm going to start moving a lot quicker because we've been going for a long time. I hope you're not too bored. We'll get to your questions. I'm sorry, but there's a lot to get through. But let's just get into collecting your debts. You don't need 45 days on your invoices. The squeaky wheel gets the oil. Change your due dates on your invoices to 7-14 days. Your current clients, who are the big clients who you think have always paid their bills on time, might not be able to pay their bills on time right now. You can't afford not getting your money. So have a look at this slide, change your terms, get some terms in place, consider getting a personal guarantee from a director. You can't collect your debts in this environment at the moment because they've changed the Corporations Act as of Wednesday, the 25th of March, where before you could, in non-disputed debts, you could go and get payment in 21 days or wind up the company. Now it's 6 months. Commercial leases. Everybody wants to know what's going on with their commercial lease. There is discussion right now. There's going to be a government release, I understand, on Friday dealing with that. And it's likely going to look something along these lines. If you have a landlord and the landlord has a mortgage and the bank has given relief to that landlord should now pass on that relief to the tenant. They are not going to say you don't have to pay rent. They're not going to say that you get to live there for free or work there for free. They're going to say it will accrue and you will owe it at the end. But if the landlord gets a benefit by law, most likely they're going to have to pass that benefit on to you. And they're also going to say that you can probably only get a relief as a tenant if you can show financial hardship. As a lawyer, you use a lot of analogies so you can almost predict what's going to happen. National Credit Code, in terms of personal lending, you have hardship provisions where the banks must consider hardship provision as a result of, for example, someone losing a job. In that scenario, you can stop the interest payments or you can stop the pay for 6 months. It's going to be something most likely along those lines. However, let's look at your quiet enjoyment, right to amenities, frustration, force majeure. If you're in a building and the government says you can't go in that building, you've just lost your right to that building. You may have a right to terminate your agreement. If it says that you're not allowed to use the elevator anymore, you've just lost an amenity to that building. You may be entitled to a rent abatement. You may be able to go and file a claim with one of the local tribunals to get a reduction in your the amount of your rent. But again, communicate. Everybody right now is being Australian. They are being reasonable and they're understanding everybody. Do the Australian thing. Everybody's trying to look after everybody. You're going to have to prove with evidence whether you actually do have a hardship. You're going to have to prove with evidence, potentially, if you do have a downturn. So don't just try to take advantage of everything if you have no reasonable grounds to do it. There's a different reliefs for small businesses And I'm going to go for 2 more minutes, but this is the cash flow assistance program. And it's basically saying, if you have staff, you will receive 100% of the tax that you withheld on your wages up to a maximum of $50,000. So I will give you, I'll give you an example. I believe it's in the next slide. We have a company, they have 12 staff. They're each on $50,000 a year. That's $600,000 a year. Your withholding tax of $8,700 a month per staff, or in total. And so what you'll do is you will then be looking at your withheld amount, which is $8,700 for the month of January, February, March, which is $26,000. And therefore the government will pay you the $26,000. You then withdraw that pay-as-you-go for April and May. That's $17,000. You can then get back $6,000 because you're now capped at 50 grand. Have a look at that example, but that's essentially another benefit on top of everything else the government has offered. And these slides now deal with some of the other questions and some of the other benefits the government has given. And there's a bunch of different guides, templates on LawPath that you can have a look at. LawPath has been around since around 2012, and I've been with them since around that date. I think it was around 2013. I have been their guinea pig for many years, working out how do we make law affordable to small businesses? How do we